Hey guys, it's Ben, Pro Se Coach here in Texas. I want to talk real quick about something that gets overlooked a lot when you're doing your hearing prep and getting ready for all of that, and that's case law. A lot of people I work with, they spend so much of their time, just trying to get their story out and get the judge to hear their side of the story that, you skip over some really powerful stuff that applies to your case, which is case law. Judges love them some case law because if you can really tie your case to a previously litigated case with a higher court, they get to kind of shrug their shoulders and say, well, then I'll just do what they said, meaning the higher court. And, there's a lot of case law in terms of family law, all the way from the Supreme Court down, that preserves your rights, disallows the court from doing many things. I'm trying to think of an example. One is just simply the process of due process. And that, in order for the court to restrict your time with your children, you must be adjudicated unfit. There's also case law about how there can be no discrimination on the basis of marriage. And what that applies to all of you is that, while you're married, you get complete total access to your children. The court is out of your hair. No big deal. All of a sudden you're single and the court's up your ass and you lose, the access that you want to your kids. So, spend some time, go to Google Scholar. So just type that in, Google Scholar. And it's it's a kind of spin-off of Google that is specific to things like case law, and start typing in, like for example, if you're looking for case law regarding an amicus, amicus attorney, Texas, and it's going to start spitting out a bazillion responses, and a lot of them aren't going to be applicable or relevant to what you're looking for. But take the time, post in our group. We have several guys in the group, myself included, that have a lot of case law up here in the noggin, and can give you a really good point in the right directions. But I'm telling you, if, in your opening statement, when you say, Your Honor, in Jones versus Jones, the Supreme Court ruled that, blah, and that's super applicable to you, it's very powerful, because judges are inherently lazy. They do not want to make hard decisions. They want to make easy decisions. That's why so many of you get screwed with every other weekend possessions orders, is because that's what the statute says. He can deviate from it all day long and come up with whatever schedule he wants, 50-50, whatever. But they don't, because they're lazy. And because it says right there that the minimum possession schedule is a standard possession order. That's what we all do. That's what we've been doing for 40 years. They would just do that again today. But there's a ton of case law that speaks to things like that, and about access to your children, time with your children, state interference. Your children have rights, same as you, and their rights get violated. What did your children do wrong? They didn't do anything wrong, so how come they just lost access to one parent? You violated their rights without any due process, simply because your ex says, ooh, he's dangerous. No, can't do that, court, and the Supreme Court says so. So, just a little bit of encouragement, man. I know it's more homework in a very, stressful job you've got here as a pro se litigant, but put in the time and it will pay off. Hey, if you ever want to talk to me, prosecoachtx.com, fill out the consult form in the middle of the page, and then you'll be shown a function to book a free call. I'd love to meet you. You guys take care. Bye.